Case Digest on Robbery in an Uninhabited Place or in a Private Building. GR number 181138, December 3, 2012, Ricky Marquez et al. Versus People of the Philippines. Elements of robbery in an uninhabited place or a private building. First, the offender entered an uninhabited place or a building which was not a dwelling house, not a public building, or not an edifice devoted to religious worship. Second, that any of the following circumstances was present. The entrance was effected through an opening not intended for entrance or egress. A wall, roof, floor, or outside door or window was broken. The entrance was effected through an use of fall keys, pitlocks, or other similar tools. A door, wardrobe, chest, or any sealed or closed furniture or receptacle was broken, or a closed or sealed receptacle was removed, even if the same be broken open elsewhere. Third, that with intent to gain, the offender took therefrom personal property belonged to another. The facts of the case: that on or about the 6th day of April 2002, in Caloocan City, Metro Manila, the accused confederating together and mutually aiding each other with intent of gain by means of force upon things, that is, by destroying the door lock of the stall of one Sonia Valderosa, and entering through the same, once inside, did then and there willfully, unlawfully, and feloniously take, rob, and carry away the following items, all belonging to the said complainant, to the damage and prejudice of the latter, in the total amount of 42,000. The issue of the case: whether or not the petitioners, in conspiracy with each other, guilty beyond reasonable doubt of the crime charged. The ruling of the Supreme Court. The Supreme Court held that the information did not specify whether the robbery with force upon things was committed in an inhabited house or uninhabited place. Likewise, the trial court, in its judgment of conviction, did not discuss whether the robbery in this case was committed in an inhabited house or in an uninhabited place. It was different, though, when the case was decided by the CA. Unlike the trial court, the appellate court discussed about robbery in an inhabited house under the above-quoted Article 299 of the RPC. In its assailed decision, pursuant to the same provision, it is then proceeded to affirm the penalty imposed by trial court upon the petitioners after finding them guilty of the crime charged. It merely stated that petitioners committed the robbery by means of force upon things, that is, by destroying the door lock of the stall of one of Sonia Valderosa, and passing or entering through the same, once inside, did there and there willfully, unlawfully, and feloniously take, rob, and carry away the items. The court, however, notes at the outset of the CA erred in applying Article 299 of the RPC. The court showed that the store alleged to have been robbed by petitioners is not an inhabited house, public building, or building dedicated to religious worship, and their dependencies under Article 299 and as defined under Article 301. From Valderosa's testimony, it can be deduced that the establishment alleged robbed was a store not used as a dwelling. In fact, after robbery took place, there was a need to inform Valderosa of the same, as she was obviously not residing in the store. If the store was not actually occupied at the time of the robbery and was not used as dwelling, since the owner lived in a separate house, the robbery committed therein is punished under Article 302. Neither was the place where the store is located owned by the government. It was actually just a stall rented by Valderosa from a private person. Hence, the application provision in this case is Article 302 and not Article 299 of the RPC.